Hello. In session number 32 of Military Law Series, we would see how does the Armed Forces Tribunal or AFT conducts its business, what rules are there uh, as to how a matter shall be taken up and disposed, and what thereafter as regards the tribunal. The tribunal, which has a chairperson and judicial and administrative members, section 22 lays down that the distribution of business among the benches would be carried out by the chairperson, who shall frame provisions as to how the distribution of business amongst the benches of the tribunal shall take place. Just to avoid unnecessarily litigants rushing to the AFT without first seeking in-house remedy, Section 21 makes it clear that tribunal shall not ordinarily admit an application unless it is satisfied that the alternate remedy or in-house remedy under the Army, Navy or Air Force Act has been exhausted, for which there are rules and regulations as to how the in-house remedy is to be sought. Further, it is said that if, when would it be said, when would it be taken that the remedy or final order has been passed? So therefore, the rule indicates that if a final order has been made by central government authority or officer or whosoever is person competent, rejecting any petition preferred or representation made by such person. So if the person concerned has already approached the central government authority or officer or person who is competent in this regard and his application has been rejected, then it would be said that in-house remedy has been exhausted. And the other contingency where the matter keeps pending. So if 6 months have elapsed from the date on which such petition was set up or forwarded, submitted, representation made, and 6 months period has elapsed, then a person can approach and knock at the doors of the AFT. There is an aspect of limitation inserted in this, where a final order which was mentioned has been made, then within 6 months the person has to approach, and 6 months shall reckon from the date of final order. A person can go and submit an appeal to the AFT, and where a representation has been made and the matter keeps lingering on before the central government or authority or officer, 6 months have expired, then it gives an scope, an opportunity for the aggrieved litigant to approach the AFT. For the sake of justice, fairness and equity, there is a provision, clause 2, which says the tribunal may admit an application even after the expiry of 6 months period, provided it is satisfied that the applicant had sufficient cause for not making the application within such period. At this stage, I'd like to make it very clear that the person who approaches AFT for any relief, the word used for such a person, he is called an applicant rather than litigant or petitioner. So we would be using the word applicant during the course of this presentation. Now, notwithstanding the outcome of a matter before the AFT, there are provisions for appeal to Supreme Court. An appeal shall lie to Supreme Court against the final decision or the order of the tribunal. So it is only when the matter has been finally decided, then a person can approach the Supreme Court, and this has to be done within 90 days of that decision of the AFT. against which an appeal is being preferred, and it is also to be understood that interim or interlocutory orders of the tribunal, they cannot be taken up to the Supreme Court. And this appeal to the Supreme Court is as a matter of right from any order or decision of the tribunal in exercise of jurisdiction to punish for contempt. You would recall that the AFT has been invested with powers of civil contempt, and if that happens where the tribunal itself has taken up and disposed the matter, awarded punishment, then within 60 days an appeal shall lie to the Supreme Court. While Supreme Court admits any matter, it may order that the execution of the punishment or the order appealed against be suspended. Therefore, say for example, somebody has been ordered to be sent to prison. Now, when he goes and appeal to the Supreme Court may decide, may order that the remand of such a person to the prison be suspended, or if the appellant is already in confinement, the Supreme Court may order his release. And therefore, the Act provides and contains adequate, reasonable opportunities for relief to the person who's an applicant. And where an applicant satisfied the tribunal that he intends to prefer an appeal, the tribunal itself may take and issue proper orders with regard to suspension or release on bail of the person. There are two very significant provisions under Section 31. Firstly, an appeal to Supreme Court shall lie with the leave of the tribunal. So, where a person wants to go and is not satisfied with the decision of the AFT, it has to seek the leave to appeal from the AFT, and AFT would certify that a point of law of general public importance is involved in this decision. So there are two grounds on which AFT may permit and give leave of appeal to Supreme Court. Firstly, that a point of law of general public importance is involved, or secondly, if it appears to the Supreme Court that the point is one which ought to be considered by that court. It may not be a point of law of general public importance, but later the Supreme Court is satisfied that this point is one which ought to be considered by the Supreme Court. The second point is clause 2, then application has to be made within a period of 30 days, and this 30 days is counted from the date of decision of the tribunal and an application to the Supreme Court. Now, between the date of decision of the tribunal and application to the Supreme Court, period should not exceed 30 days. It is from the date on which the application for leave is refused. This is in case the tribunal refuses to give an application, a leave to appeal to the Supreme Court. Now, there's certain case law. Balakrishna Ram's case is of 2020, where the Supreme Court held that in relation to orders passed by the AFT, high courts would be justified in exercising their writ jurisdiction in case there is some glaring illegality committed by AFT. So, please remember that the jurisdiction, which would be a writ jurisdiction of a high court, may be invoked if there is a case made out for a glaring illegality having been committed by AFT. And exercise of writ jurisdiction on orders of AFT is within discretion of High Court, and there cannot be a blanket ban on exercise of such jurisdiction. Now, such an opportunity had arisen because a contention was being made that having regard to the provision which says an appeal to Supreme Court only, the authority of high courts to go into a matter before AFT or a matter decided by AFT doesn't exist. So this notion had been was set to rest by this Balakrishna Ram's decision that if there is a glaring illegality, then certainly High Court may decide to take up that matter and intervene. There is a Supar Virendra Kumar's case where the Union of India went in Supreme Court and the matter pertained to retrial. It was held that retrial may be directed only in those cases where the evidence made available to tribunal was not produced before the court martial, and if it appears to the tribunal that interests of justice require retrial. So here was a case where there was certain evidence which was not produced before the court martial. An appeal comes to the tribunal. This evidence is presented first time to the tribunal, and the tribunal takes a view that interests of justice require retrial. Yes, Supreme Court said in Virendra Kumar that retrial can be taken up. Then in Karthik's case, in the same year 2020, in a matter which concerned sections 30, 15 and 3F, it was held that tribunal is within its jurisdiction to set aside dismissal order, finding it to be disproportionate to alleged misconduct. Supreme Court, in exercise of its appellate jurisdiction under section 30, would be slow in interfering with substituted punishment unless order passed by the tribunal is patently illegal, warranting interference. Now what happens here is that certain punishment had been given with regard to, or certain order had been passed in a matter of alleged misconduct, and when the matter went to the Supreme Court, before that the tribunal had interfered with that order. So therefore, the Supreme Court said the tribunal is within its jurisdiction to set aside that dismissal order if it was disproportionate to the alleged misconduct. Now, obviously, this was a case where the action taken by the authorities was held to be too harsh or too severe, which led the tribunal to set aside that dismissal order in that case. Because dismissal order obviously means separation, administrative separation from the service. Then in Commander Ravindra Desai's matter of 2018, it has been held that scope of appeal to Supreme Court under section 30 and 31 is limited to the point of law of general public importance. So this obviously has been done and a view taken to accord finality to the decision of the AFT and avoid unnecessarily, as a matter of course, appeals being made to the Supreme Court. In the end, I would like to emphasize and highlight that right to appeal to the Armed Forces Tribunal, and thereafter with regard to its decision to the apex court, have been fine-tuned by these case law to ensure the efficacy of the AFT jurisdiction, so that in all cases, as a matter of course, litigants, applicants do not rush to Supreme Court challenging the decision of the AFT. Thank you.